I'm Frank Lacquaniti, as Lauren said, a partner with Arias Bossinger. Arias Bossinger is a community association law firm. It's our primary practice area. We have 4 attorneys who are certified as experts in condominium law, amongst other community associations. I am one of those attorneys. We provide comprehensive legal services for community associations. Essentially, it's from beginning to end. We can handle everything in between. And one of the things we are currently dealing with are some of the legal updates and really the fallout, and I'll say the preparation for some of the upcoming issues that we're going to be seeing with respect to the update. Really what happened this year, the legal update, really fell into Senate Bill 4D. It's called the Condominium Building Safety Act. It's been widely published. In fact, I heard from some people after I did one of these that there was a discussion actually about the new law, and it made it onto 60 Minutes. It really was in the context of Surfside. And really, Surfside is really the impetus for this entire change in the law that was made. Specifically, the Surfside situation was a condominium association that over time had failed to maintain the actual structure of the buildings. As a result, essentially kicking the can down the road, the building collapsed. I'm sure everyone knows what I'm talking about. There was initially some indication that they were going to try to address this in the original session. But you may recall Governor DeSantis called a special session of the legislature to address insurance reform. Part of the insurance reform was to go back and discuss Surfside because that was still fresh in everybody's mind. And the belief was that the two would go hand in hand. If you maintain your buildings and maintain the structural integrity of that building, there's less likely to be damage to that building that could result in insurance claims. The downside of it was that they had, when the legislature first did this before the special session, they hadn't really fleshed out and really thought through all of the different issues that they were actually working through. So what they ended up doing was having this bill that was kind of pieced together. It got lost in committees, which is the step before it makes it to the floor. And the long and the short of it was that we kind of got pushed out to the people. We kind of got caught in a perhaps incomplete or not completely thought through bill. So we're still dealing with the fallout. Now, since this has been pushed back, we're actually starting the new legislative session. And I do know, and I've heard from various sources, that there are many potential fix bills that are out there. So far, those are in the works. They are not official. There's been no formalization of anything that is going to make it actually to a vote and then eventually to DeSantis's desk for signature. However, there is a lot of discussion out there that there will be some fixes. So I'm going to point out some of the issues that we've encountered and that we're seeing with the statute as we go along with some of the potential fixes that they have. However, as a precautionary note, this is a statute that was designed specifically to address a specific life safety and welfare issue. As a result, there is a strong public policy argument for why this particular statute is in effect. And when that happens, and you have kind of the weight of public policy firmly at your back when you're trying to enforce something along these lines, it gives the association that's trying to poke holes in it very little opportunity to do so, because in essence, it's going to be very broadly interpreted. This is different than perhaps some of the other things that we do where you'll say, hey, this provision says this owner is not doing that. And you go to your attorney and they say, well, it's going to depend on a series of factors and ultimately what the judge decides. Here, I think the weight and thrust of this bill and the importance it serves, despite the fact that it has a lot of flaws, is actually going to work against the association. So I don't believe that the association should be looking for ways to get around it. I think the idea, unless and until they adopt some changes to the statute, you follow what's in the bill. You don't want to be on the losing end of this for a variety of reasons, including the fact that it is intended to protect the health, safety, and welfare of the residents. However, that comes along with a lot of the financial burdens that are presented in the statute. So with that kind of summary and introduction in place, let's get into a little bit more of the details. So it's called Senate Bill 4D, or the Condominium Building Safety Act. You might hear it. I've also heard it referred to as the Surfside. So what does it entail? There's first a reporting requirement in it. Now, this is the first where we're going to start getting the idea that there's going to be a bit more governmental oversight on what condominium associations are doing. Keep in mind that this presentation, we initially started giving it right after the bill passed, was in about mid-2022. So now the deadline to actually register the condominium has passed. Hopefully, everybody on this Zoom meeting this evening has already registered their condominium. The registration process is very, very easy and requires very few things. It's the number of buildings that are 3 stories or higher in height, the total number of units in all such buildings, the address of such buildings, and the county in which the buildings are located. To my knowledge, the only thing that's going to be done with this is to create a directory or a set of parameters to catalog all the communities in the that meet these different requirements. And as you'll see as we go through this, a lot of this coincides with the different requirements that are in the bill. What's interesting with it is that we don't know, outside of what I said of kind of cataloging communities, we don't know actually what the division, if anything, is going to do with them. Kind of a spoiler alert, the division doesn't really have any other obligations under this bill. There is a component that requires local governments to be involved a bit, but it doesn't actually assign the division any particular responsibilities. The only real responsibility they'll have is their usual oversight over condominium, which they do now over the reserve accounts and that kind of thing. They'll still have that when it comes to the structural integrity reserve study, which we'll discuss a little bit later. It says it must be provided. The DBPR did open up. It's a portal thing. It's kind of an online form that you fill out and you submit. So it's not particularly complicated to do, and it's relatively easy. So if you haven't done that, you really should get out there and do it. The big change is really the milestone inspections. The milestone inspections are structural inspections of a building, including an inspection of the load-bearing walls and the primary structural members and primary structural systems of the building. This is obviously intended to serve that very important purpose of looking at the structure of the building. The structural inspection must be performed by a licensed architect or engineer, attesting to the life safety and adequacy of the structural components of the buildings, the structural condition of the building affecting life safety, and any necessary maintenance, repair, or replacement of structural components of the building. There are ultimately 2 types. So what we have here is actually the first you're going to see kind of an interesting component where we're going to have we'll call them a neutral third party, so to speak, that's going to be looking at your building to determine if any repairs or replacements are needed of the building. And keep in mind, it has to be by a licensed architect or engineer. Where this becomes a little bit different is that typically this is not done by a licensed architect or engineer when you're getting your current type of reserve study. So it's unusual to have a licensed architect or engineer to come in, even if there's no particular indication or reason to come in and look at the property, whereas you may hire a licensed engineer to fix an already existing problem or one that you know of. So that's why we're first seeing that. And with hiring of licensed individuals, you can probably guess it's going to cost a bit of money. So who has to get the milestone inspections? So all buildings 3 stories or higher must complete the inspection by December 31st of the year in which the building reaches 30 years of age, based on the certificate of occupancy, and then every 10 years thereafter. So when we look at that, we see there's a requirement of buildings 3 stories or higher. This has become a very big hot button issue for many communities. The reason why is that the milestone inspections seem to indicate, the way it's worded currently, that it really only applies to buildings 3 stories or higher. So the natural question is, if you are a community with mixed size and types of buildings, how does this apply? Well, the argument, and currently under the statute, would be it's only those buildings in the community that are 3 stories and higher that actually must be inspected. There is a practical consideration that if the person's doing considerable work anyway to get out there and doing the milestone inspections, it might make sense for them to look at all the buildings in the community as opposed to just the 3 stories or higher. But right now, the way it's worded, it appears to only apply to those buildings that are 3 stories and higher. So if you have a condominium that's made up of 5 3-story buildings and then several 1-story or 2-story buildings, the 5 3-story buildings would be the ones that need to be that are subject to the milestone inspection. There is a caveat. As we know in Florida, water is prevalent. We have moist air in general. It's very humid here. We also have a lot of properties along coastlines, and water is known, in addition to just regular rainstorms, I should say, we have quite a bit of those. So water is prevalent in Florida all over the place. And water is known to have a very, very detrimental impact on almost anything, including our buildings. So what they've done is they've created where it's very likely there's a lot of water deterioration or enhanced deterioration. They've added an exception for within 3 miles. Inspections must be completed by the December 31st of the building reaches 25 years of age, and then every 10 years after. So you accelerate your timeline by 5 years if you're within 3 miles of the coastline. An interesting point that we're hoping gets fixed. There are communities that happen to be located partially within that 3 mile range and partially outside of that 3 mile range. What's interesting about that is you'd ask the question, well, do only the buildings within the 3 mile range have to be at 25 years? And then those that are outside, that are 3 stories or higher, have to be within 30 years? Can we split the baby? Now, of course, the conservative approach to the answer to this is going to be anybody that's falling within that 3 mile radius, if you happen to have more buildings, would likely just to get them all done at 25 years. But, there's this argument, we're hoping to get some clarification on that because there are a couple concerns about how that 3 mile radius is accounted for and what happens if someone falls within that general range. So when must you comply with this new requirement for these milestone inspections? Buildings with COs on or before July 1, 1992 must complete their milestone inspections by December 31st of 2024. And then buildings within the 3 miles of the coastline with COs on or before July 1, 1997 must be before December 31st, 21. So what you'll see there is, again, we have an accelerated timeline of 5 years. So there is that shift for those closer to the coastline of 5 years. There's an interesting thing, and I've noticed, so a lot of what's happening now are not newer condominiums. Those that are created before July 1992 are required to get their inspections done by December 31st, 2024, and then your coastlines, you have that 5-year change. Some of these older condominiums, at least the ones that we represent, and anecdotally from talking to clients, really have no particular way to identify when the first CO was issued. So what we're looking at then is going back into the official records of the county to find out, the local building officials, to find out from them when they can reasonably identify when the CO would have been issued for a particular building. Anything that really evidences the occupancy date would be reliable. I would suggest, however, or I do suggest, if you're a community and you're looking at your governing documents and they're 50-something years ago, I think it's pretty reasonable to assume that you're going to fall within this December 31st, 2024 deadline, one way or the other. It just is, it's unreasonable to think that the first CO was not issued within this 30-year window or 25-year window, if your documents are that old. It would be very rare that the condo would start and then you would have a CO issued 20-something years later. So that seems unlikely. So that would be something I would just preliminarily look at without getting too detailed. So if you see documents 40, 50, 60 years old, which is not uncommon in Florida, I would start paying attention to milestone inspections right now. If you're on the cusp, you might want to dig in with your local building officials to get a handle on when they think the CO is issued, and then come up with some reasonable guideline as to what they think the date may be for occupancy. When it comes to, I made a comment earlier about the division, and they were going to be collecting this information about condominiums and when the counties that they're located in, a little bit more information. There is a requirement by local enforcement agencies to provide notice by certified mail that they must comply with their milestone inspection requirement. And then it says, upon receiving the notice, associations will have 180 days to complete the phase 1 inspection. Right now, to my knowledge, I don't know of any county that has been able to effectively implement this. As it is, code enforcement, zoning officials, all those kinds of local government entities are slammed with all the things they've normally been tasked with. What's going to have to happen here is that our local governments are going to have to kind of unify and figure out a way that they're going to properly notify condominiums. This is not something that's ever been done before, and there's going to be some governmental oversight on this. It's just very difficult implementation and something that was just sort of thrust upon the local governments to handle something that they've never handled before. Right now, I'm not aware of who, even using Orange County, Seminole County, Osceola, I'm not aware that this has been firmly established within those departments that they're going to be looking at this. But presumably, the information that's collected by the division about the different condominiums in the counties is going to be disseminated to the local governments, and then the local governments are going to be tasked with giving these notices out. How about this notice then? So maybe you're on the board of a new condominium, and maybe you're 25 years and you're here locally in the Orlando, Orange County area. And you're thinking, well, we'll just wait till we get this notice. There are several concerns with waiting or relying on this government enforcement agency. One, we don't know how it's actually going to be effective right now, how they're going to do it. Two, it only gives you 180 days to complete the phase 1 inspection. My understanding is there's going to be a limited number, and there currently are a limited number of licensed architects and engineers who are willing to get involved with these milestone inspections. More so the ones that are doing it, once we get past that hurdle and we find some, you're going to have some issues potentially with getting that person to get out to your project. Because then if they've got people that were in front of you that also got their notices, there's going to be a long laundry list of things that they have, communities they have to serve, and they may not be able to get to all of them with the amount of work that's required. There are entities out there doing it, and there may be some that may be able to comply with this. However, if you're on the board of directors, it's better to be proactive and mark these timelines and work with your management companies to figure out when you think your timeline is going to expire, your legal counsel if necessary, to get all these different timelines in place so that you know when you get your milestone inspection, so you're well out in front of it. And that's just, it's sort of common sense. And as we'll talk about later, there are actual liabilities for not doing these things. So getting out in front of it and staying out in front of it is probably a really, really strong idea. There are some exemptions though, and this is another area that we're hoping to get some clarification. So it says who is exempt. It does not apply to single, 2, or 3 family dwellings with 3 or fewer habitable stories above ground. So there's a variety of different things that can happen here. The term single, 2, and 3 story or family dwellings is really not defined in the statute. We have a commonly accepted term. So if you said to me, Frank, oh, we're a single family home, I'm going to know what that means. 2 family, that I guess would be, just assume it means 2 people living in a building, and then 3 is the same way. There's no real question about whether or not, so if a garage has stairs that go up to a 2nd story, does that consider a habitable story? So you have a 2 family dwelling with a garage on the bottom, or you have different arrangements that can arise. You're not really sure who it falls under because it's really just one minimal statement in the statute that you're really looking at to determine whether or not you're exempt. So when it comes to, again, with this, we're not trying to find loopholes. So we're going to go with the black letter and just take the commonly accepted definitions of these terms to figure out whether or not we're responsible for getting a milestone inspection. So that's really the parameters that they've given us. So there's really few exemptions. It's the exemption we just talked about. And then it's really every other building 3 stories or more that's going to be going through these milestone exemptions. So now we get into more of the nitty gritty. What is the phase 1 inspection? A phase 1 milestone inspection. It's a visual examination of a habitable and non-habitable areas of a building, including the major structural components of a building, and provide a qualitative assessment of the structural conditions of the building. If the architect and engineer find substantial structural deterioration to any building components under the visual examination, a phase 2 inspection is required. Okay, so it sounds pretty basic. We're going to have a licensed architect or engineer go out and examine our buildings, and they're going to do a qualitative assessment of these structures. I've heard a lot about this now. So there's a lot of different considerations here. One, as I've mentioned before, using a licensed architect or engineer is likely going to be an expensive proposition. Depending on the size of your community, the number of buildings, or the height of your buildings, there could be a variety of different things that come along with that. I presume, and my assumption from just hearing those in the industry, that the more buildings you have, the more expensive it's going to be. The higher the building it's going to be, the more expensive it's going to be. So you're going to have this person going out and you're kind of compounding your expense because you have these licensed architects and they're going to be looking at all these 3 or more story buildings. We get to the second part of this, the milestone inspection. You now have someone who's licensed by the state of Florida to examine a building, the structural integrity of a building, with the reliance of I'll say the community association, so most likely the condominium association, the reliance by the condominium association on this report to pass this off as saying our buildings are structurally sound. We don't need to do anything different than the maintenance we've routinely been doing. It's not likely that anyone that is upholding their fiduciary duties as a licensed engineer or architect are going to overlook anything that could be signs or indicators of actual damage to the building. I mentioned water. Water is a great example. You could have a tiny, and some of you on this call have probably seen this in action. You can have a tiny break in stucco or tiny break in a shingle or something. And over time, you can't see it, naked eye, we have no idea it's happening. But over time, that water goes in and drips in, drips in, drips in, and it starts filtering throughout the building. That can have, in older buildings, because keep in mind we're talking about older buildings, can have a very, very detrimental effect to the structure of that building. So if the engineer starts seeing things like this, that is likely going to be a red flag for this architectural engineer. So the phase 1 milestone inspection is very, very likely, unless your buildings are pristine, to result in an automatic phase 2. Because if you're looking at a visual examination, you don't know what's under that surface, and you see areas where water intrusion is likely, it almost begs the licensed architect or engineer to take a deeper dive, because again, this is a qualitative assessment of the structure of the building. So it's very likely that they're going to then follow the components of the statute, which then trigger the phase 2 inspection. So where we're concerned with this is that they didn't carve out any particular exemption or, safe harbor for the engineers or licensed architect doing these inspections. So it's then up to using their own judgment as a licensed architect or engineer to determine whether the phase 2 is necessary. And almost anything in the visual realm that could lead to interior or structural damage is likely necessitating a requirement in good conscience, the phase 2 inspection. So we're hoping that this is one area that's addressed, that it one gives a little bit of power back to the licensed architect engineer. We don't want them to be able to shirk their duties and just say, hey, yeah, they just sign off on everything, because that doesn't accomplish the goals of what the legislature is trying to do with building safety, which is in fact a laudable goal. But we also don't want to bury our communities with constant overbearing and very, very expensive inspections just because the licensed architect or engineer doesn't feel that they're safely protected under this statute by the current verbiage and are required to dive further if they see something they don't like. So then we move to phase 2. So now we have an architect or a licensed engineer, they're out there, they're looking, they see something that warrants further investigation. That moves us to that they're required to then do the phase 2 milestone inspection. It must be performed if any structural deterioration is identified during the phase 1 inspection. The inspector may require destructive or non-destructive testing at their discretion. When determining testing locations, the inspector must give preference to locations that are the least disruptive and most easily repairable while still being representative of the structure. The inspection is as extensive as necessary to assess the areas of structural distress in order to confirm that the buildings is structurally sound and to recommend a program for fully assessing and repairing the distressed and damaged portions of the building. And then the inspector is required to prepare an inspection report. If you recall, we talked about the phase one, and I say beat this over the head, but we have destructive and non-destructive testing. If you're doing a visual inspection and you believe there is substantial structural deterioration, the only way you're really going to be able to go by that into this next phase and to get into what's happening inside the building is through destructive testing. Non-destructive testing would indicate to me that everybody already knows that the roof is gone or it's substantially deteriorated, in which case the board already has the task of and should be making preparations to repair that. So that's not new or different. I think the issue is going to be that you have to do this destructive testing. Destructive testing becomes an issue because, as I mentioned, I use water leaks because we deal consistently with water leaks. And water has a way of getting to wherever it wants to go. It may start in one spot and then ends up somewhere totally different. That now puts on this burden on the licensed engineer to start doing some sort of destructive testing within the building to try to figure out all the different places that they're going to do this testing. It's on the architect to make this, or the licensed engineer to make all these determinations. That in itself can become a daunting task. When you think about the size of a building and where water could go, you may end up with all these various holes. So now as we start doing these holes, now we're thinking two things. One, more time by the architect, and two, more repair costs. I'm sure the good architects will have ways to minimize that, but again, we're compounding the cost of this. And then the inspection is as extensive as necessary to assess the areas of structural distress. What are we doing here? We're now putting even more obligation on this licensed architect or engineer who, if they're worth their salt, is going to do a thorough job, because again, as a board, you're now relying on the licensed engineer and architect that you hire, you're relying on them to make these determinations that this building is structurally safe, and there's really no additional work that needs to be done because they're supposed to be pointing it out. So we're putting a lot of burden on the licensed engineer and architect. And when you're hiring these people, the people that are worth their salt are likely going to do a very thorough analysis, and it could end up just becoming a very expensive proposition for the association overall to really get this project done, which is what part of this concern is with this whole entire bill. The intention is very good, but we seem to be piling on costs, if you can't tell, which is why I'm kind of emphasizing that, because this is something boards really need to plan for and prepare for, because this is an expensive endeavor. So now we have even a new thing that happens here. So we get done with the inspection. The inspector actually prepares a report. The report is actually prepared by this licensed architect and engineer, and it's prepared. It contains everything that they did, everything that they saw, everything that they found, all the different destructive testing. This report actually gets submitted to the county, gets reported to the local agency that's reviewing these things to ensure that the government is aware of all the different issues. So this is where now we have this department that is essentially being created by our local governments to address this, or being handled by an existing department, but expanding their scope of duties to this government. Now we've got another layer. What's interesting about this report is that it gets sent to the county at the same time it goes out to the association. So there's not going to be a lot of wiggle room. It's not something where you can say, oh, can we adjust that? Can we do this? You're really getting a true and accurate representation based on what this licensed engineer or architect finds. To me, that is a potentially problematic area because you're now going to have something, and this is from the lawyer standpoint, on record that's going to have a recommended course of action. So what is this report going to say that's now submitted? It has to bear the seal and signature of the licensed engineer or architect who performed the inspection. Again, this incentivizes the engineer and architect to do the absolute maximum to make sure that whatever they've done is adequate for the health, safety, and welfare of this community, and to ensure these buildings stand the test of time, so there is no additional Surfside. It has to indicate the manner and type of inspection forming the basis of the inspection report. Again, this now sets up the framework that if something happens after the fact, this licensed engineer or architect finger can get pointed back at them and saying, oh, you should have done X, Y, and Z, but instead you only did these things. That again incentivizes them to maximize what they have to do. They have to identify any substantial deterioration within a reasonable professional probability based on the scope of the inspection, describe to the extent of such deterioration, and identify any recommended repairs for the deterioration. This is where they're putting the association on notice of what's likely coming down the pike for you. And now you have it on record that these are things you have to do. You have to state whether any of the unsafe conditions or dangerous conditions were observed. Then you have to recommend any remedial or preventative repair for any items that are damaged but are not substantial deterioration. So now if you caught that, it's repairs that are damaged but are not substantial structural deterioration. You're probably thinking, hey, didn't you say all of this is based on substantial structural deterioration? Well, now they have expanding the scope that there's all sorts of other things that they could be looking at and should be looking for when they're doing this report. And then they have to identify and describe any items requiring further inspection. That part is very concerning because they could just say, these are all the things that I saw were substantial deterioration. Here are all the other things they should be looking at. So now you've got a laundry list that essentially rebuilds the condominium. And I don't know how that's going to be really play out. This is one area where they're really hoping to get a bit more perhaps clarification, rein it in a little bit, give the licensed engineer or architect some sort of maybe shield or a little bit more guidance or something that kind of carves out some exceptions that they can do all of this work and really do a really good job for the association, but not try to identify every single thing that's wrong to protect their license because they've undertaken this project. So it's a particular issue. What's fascinating about it is that it's going to put forth a repair plan and identify this repair plan and the work that needs to be done. That is, to me, very unusual because you're essentially getting a roadmap of things you now have to do, and you don't really get a chance to maybe shop it around, get different opinions. That's not to say that you can't, but again, you're now going to file something with the county, and it's going to become essentially de facto evidence that this is something you should have done if something else happens down the road, perhaps something more unthinkable. So we're hoping for some clarification on this because it's imposing quite a bit, quite candidly, on the engineers, in my opinion, and on your architects that you're hiring. It also leads to the potential that you're going to have substantial issues down the road with setting up liability for not doing these things. That's really, I know, really the lowdown on this phase 2 milestone. And I just think it paves the path. I keep saying this, but it paves the path to a lot of problems for the association because you're going to get this report and you're essentially going to be tasked with undertaking these repairs. I think fundamentally a condominium association, of all the things it's really supposed to do, it's to protect and preserve the common elements. The common elements support all the individual unit owners' units. And fundamentally, that's really why a condominium was created, was so that this basis could be put together. That the idea is that this condominium association is actually protecting all these investments for all the different units within there. So that's why I think it's tough, puts the boards in a tough position. And also, as I've said before, puts the licensed engineer and architect in a tough position. The phase 2 milestone inspection report does not determine if the condition of the existing building is in compliance with the Florida Building Code or the Fire Safety Code. I find this fascinating. I don't know who is going to be reviewing these in the local counties, but presumably you're going to be identifying the rebuilds. With rebuilds, because again, I just want to say, I'm using the term rebuild, you're going to have we're only talking in theory about substantial structural deterioration. Substantial structural deterioration, in my mind, is something that is going to actually need to be reconstructed or rebuilt. It's not a simple re-roofing or just painting the exterior of a wall. We're talking about something significant that's going to be structural components of this. At least in my mind, that's how this is going to work. What they did do is, this is where we get to the phase 2. This is the carve out in this inspection report. Substantial structural deterioration does not include any surface imperfections such as cracks, distortion, sagging, deflections, misalignment, signs of leakage, or peeling of finishes, unless the licensed engineer or architect performing the inspection determines that such surface imperfections are a sign of substantial structural deterioration. In my estimation, you are not going to find many licensed engineers and architects that are going to find any type of sagging, deflection, misalignment that is not, or peeling even, that's not also going to do a deeper dive into that, because as I said, water is a very destructive force. So I don't think that gives up the licensed architect or engineer sufficient basis on which to not look further into that. So again, this is one of those areas, along with all the other things, that they're trying to really put better framework around this milestone reports for the licensed architect and engineer, so maybe make not this not so daunting for them. So an interesting thing about this bill, what I would say, the way I look at it is that you kind of got the impression as you're going through it, the milestone inspections are thrust upon every condominium. You have your 30-year, 25-year, and then every 10 years after. You have these giant reports done, okay? So you're getting all that taken care of. That's a very reactive thing. It's a very reactive approach. What you're trying to do at that point is get your hands around everything and say, this is all the buildings as they exist and they're deteriorating. The issue is not so much for new condominiums that are coming online that are going to have it. It's just really, we're looking at older condominiums that weren't properly maintained, or we didn't know were not being properly maintained, because it's all this interior substantial deterioration. So the bill is really divided into two components: your milestone, which is checking the existing status of, and then setting forth this requirement to repair any substantial deterioration, and then kind of that whole reporting process. And then you've got the second component, which is really intended to be, at least in my opinion, is intended to be somewhat proactive. That's to say, we know all of this is going to cost a lot of money. We know upkeep, the building upkeep is could be expensive. So we're going to create something called a structural integrity reserve study, which is separate and apart, though overlapping, from your current reserves. So you have a second component. And what this is doing is intending to get the money into your reserve accounts, so you at least have something as a board to rely on over the long term that you're going to be using should there be some deterioration, that you can use this money to fix those things, or not let them happen. It gets to the point that when you get to your milestone inspection that you have to do this substantial work, and it kind of just blindsides the association. I think the intention here, get the funds, get them in place, and keep them in place over time. So what is this? Who must comply? You'll hear me use the term SIRS. Our slides all use the term SIRS, but that stands for Structural Integrity Reserve Study. So who must comply? All unit owner-controlled condominiums and co-ops existing on or before July 1, 2022, with buildings of 3 or more stories must obtain a SIRS. There is no exception in this particular statute for those single-family two family homes and 3 family homes. It's simply 3 or more stories. This likewise applies. You're going to have to do a SIRS. The way the statute is written, and the only real way to interpret it, is going to be if you have a condominium that exists with 5 buildings of 3 or more stories, and then several 2-story buildings, that cost will have to be borne by the association, even though some of the buildings don't have to fall at that. If your condominium is set up such that maintenance, repair, and replacements are part of the common expense, then this also needs to be part of the common expense, which is something that we're hoping gets resolved, because there's been a lot of issue with that, where a community may have 1 3-story building, everybody else single story or 2 stories. All those people are now going to have to pay for this 3-story stuff, which could get expensive, and have to contribute to the SIRS, which may only apply to that particular condominium. The one building in that condominium. The SIRS must be completed by December 31, 2024, and then again, at least once every 10 years thereafter. The SIRS has to be performed and obtained from a person who is qualified to perform such study. However, the visual inspection portion of the study must be performed by a licensed engineer or architect. Presumably, the whole thing is going to be done by a licensed engineer and architect. That's my takeaway from this existing language. So what is the SIRS? The SIRS must identify the common areas being visually inspected, state the estimated remaining useful life, state the estimated replacement cost or deferred maintenance expense of the common areas being visually expected, and then provide a recommended annual reserve amount that achieves the estimated replacement or deferred maintenance expense of each common area being visually inspected by the end of the estimated useful remaining life of each common area. This should sound pretty substantially similar to what we currently do or currently have in place with respect to every other reserve and the way things have been done. It's more or less the same concept, except for the fact that they've created different components that have to be included in this. So the SERS components include the roof, which has always been the case, load-bearing walls and other primary structural members, the floor, the foundation, fireproofing and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows, and any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000, and the failure to replace or maintain such item negatively affects the above components. This area is one that we are certainly hoping for some clarity on. In particular, so for example, in particular, we've got a couple of things here. The one is the waterproofing and exterior painting. That's already been a reserve account. They need to make it very clear that this is not an item that if you reserve for it in your SERS, based on your SERS, that it is specifically excluded from every other reserve account. The reason for that is it just provides the clarity, because this doesn't remove or otherwise change necessarily what happened in our existing reserves. However, many of the items overlap. So it would be nice to achieve some sort of harmony between the different provisions. That's one thing that we're hoping. Two, it requires things that may not be the association's item to repair or replace. For example, windows. Windows are very commonly the unit owner's responsibility to repair and replace. Yes, they serve a very important structural component of this, of the building, because if you don't have a good seal, water gets in, destroys the rest of the building. However, if you've delegated the windows to the owners, you're in essence going to have to reserve, based on the existing version of the statute, for replacement of all the windows. However, when it comes time to replace, the owners are supposed to be the ones doing it. So we need to get some sort of clarification on this, that because it's now included in the SERS, it's always the association's responsibility, which raises all sorts of issues. Or if it's delegated to the unit owners, then the unit owners are responsible for it. And getting that kind of clarity is going to be, I think, critical over the long run, because it's going to create all sorts of weird components. That does the association just have to reserve now for, it could be hundreds of windows. And then you say to the owner, well, you're responsible. They say, well, we've been reserving for years. You should replace all the windows. It's a very obvious problem. Another one is the foundation, the foundation in general. This is an example of where, sure, from a kind of a 30,000 foot view, yeah, certainly the foundation is a structural component of the building. I don't know how any, and I'm not a licensed architect or engineer. I wasn't introduced as such, and I'm not pretending to be one. However, if you were to say to someone, you have to repair or replace your foundation, it seems to me that the building is lost at that point. There's really no way to tear everything down and then build it back up again and say that the foundation is completely repaired. And there's really no kind of carve out for it. So you've got these reporting that you're not really sure what's supposed to be in it and how much you're actually supposed to reserve for. So again, we're hoping for some clarity on these types of things, because that just seems problematic to me as a whole, that you're going to get a report, you're going to have to reserve for replacing, I guess, the foundation. And there's no real guidance to how this amount is supposed to be accounted for, and then how you're going to defer the maintenance on. So the new reserve requirements, the amount to be reserved for an item is determined by the association's most recent structural integrity reserve study that must be completed by December 31, 2024. And that just applies across the board to all condominiums that have buildings 3 stories or more. So you're going to need to get out there and get someone going. And effective on December 31st, the members of a unit owner controlled association may not vote to waive or reduce the reserve for SERS building components. What this generally means is that the association is going to have this report and is going to be required to fund based on this reserve report at that stage. This is likely going to be a very expensive proposition for the unit owners, particularly because a lot of these items may not have been included in your original reserve studies that you've been relying on for years and years and years. And as I mentioned, there is some overlap between the different components of the building, what is reserved and what is not. So this is something that as boards really need to be prepared for. What's baked into this and begs some clarity is the question of whether or not pooled reserve accounts can be used. There is a very, very strong argument that pooled reserve accounts cannot be used for anything in the SERS. The reason for this is that essentially when you take money out of the pool for one item, you're necessarily depleting or reducing the reserve for the other item. That's just the nature of the pool. It's why people like pools, because it gives so much flexibility with how you spend the funds. It is not explicitly stated, but it is implied in this that they're going to be essentially straight line accounting on the SERS. That is obviously subject to debate, but and a different interpretation. But just from a general practical standpoint, if you can't waive or reduce them and you have to fund them, it doesn't also make sense that you could just fund at the pooled methodology and then be light on the funding later to fully fund it, and you can't otherwise pull that money out. The reason why we're hoping for some clarification is because by December 31st, 2024, essentially starting in 2025, people are going to start, or communities are going to start funding these things. And we don't want to end up with a big pooled reserve accounts, and then we don't know what to do with them because we're technically not supposed to waive them or reduce them. Or we get a reserve study that comes back and it shows this foundation, and then they ultimately pull that out. So we're hoping to get clarity maybe in this cycle before we really get this thing fully up and running. Again, areas of clarification, they are being discussed. I have heard this kind of through the industry that these particular items, that these are not new, they're well known, and that we're hoping to get clarity on. So let's talk about some of the statutory liabilities. If the association or the board fails to obtain the milestone inspection, so it's willfully or knowingly fails to have a milestone inspection performed, such failure is a breach of fiduciary relationship to the unit owners. I know it says willfully and knowingly and all that kind of stuff. You do not want to be the board of directors who did not timely obtain this milestone inspection. I don't really want to be the one, based on the thrust of this whole statute, I don't want to be the one to have to be defending it either. This has a very strong public policy, which I touched upon when we started, and you don't want to be the community that's pushing the boundaries of this and saying, oh, we didn't know we had to do this. We didn't knowingly do it. We just forgot for some reason. I think that's built in the cases where someone kind of has a gotcha moment where you go out and you say, hey, our condominium, we can't find a CO. We would go out to the local building inspector, they show a different date, and someone says, oh, you missed the deadline by a year, and someone tries to gotcha. I think in that case, you have a pretty good defense to this. But if you're just not doing it, I don't care if you didn't know, you're going to claim ignorance or that kind of thing. I don't think that's going to be a good defense, and especially when it comes to something of public safety. The failure to obtain the SERS, there's really very little defense to this. The SERS is something that condominiums have to be doing. There's really no particular timeline other than these initial timelines. It's something that has to be done. Communities are already obtaining reserve studies, so it's not that much different. How they're implemented is a bit different, but outside of that, it's really something that's already been done for years, and it's not new to the condo realm, so reserving for something in a reserve study. So this is just something that needs to be planned for and addressed because you're going to have to start funding these things. There is an interesting component about the manager duties. If you heard the Surfside case, there was a lot of discussion about what the failures were there. Kind of my understanding of it was that there were a multitude of failures. One of the things was that the board of directors just would put out to the membership the ability to vote on these things. The unit owners would say, no, we're not going to do it. And that kind of ended the discussion, ultimately resulting in the death and very tragic event that it was. What they did is they actually included, one of the people cited in that was the management company. And they added to chapter 468 kind of this sort of nebulous language that says if a manager or management firm has a contract with the association that is subject to the milestone inspection, the manager or management firm must comply with requirements performing such inspection as directed by the board. Well, if the board of directors directs the management company to not do it, it kind of seemingly absolves the management company from having to do anything. However, I don't think it's that clear. And I think the inclusion of this was really intended to put the management company on some sort of notice that, hey, you've really got to push these people to do the right thing if they're failing to do it. And then maybe have what I call the noisy exit from the board. And the noisy exit is essentially throwing your hands up and saying, I resign, so everybody remembers your loud and noisy exit, so to speak. With that, I would also say if you're on the board of directors, because of this kind of built-in breach of fiduciary duty, I would be pushing very hard your other board members to make sure they're doing these compliance checks, making sure they're following with this reserve requirements and the milestone inspection. Once, despite all the kind of the negativity that I shed towards it, because there is, I just think this is an overwhelming kind of course change for condominiums, that it kind of went, well, it's over here, we're all doing this, and now we've got to pivot and go over here, and now we're going to have these extraordinary costs. We're going to be funding all these new reserve accounts we haven't properly funded. I think once we get over the hurdle, hopefully with some changes and clarifications to the statute, maybe some relaxing of some things, that there is a good intention to a lot of this, and I think it's going to alleviate some of the problems that condominium associations are facing. Because one of my pet peeves as an attorney is when I sit at a meeting and I hear everyone and they're sort of bashing the board of directors for saying, oh, you raised our assessments and because you're trying to fund these reserve accounts and it's too expensive, why don't we just waive them? By doing a lot of the things that they did, they've given the board a lot of protection to do the right thing, which is to properly fund, because those same people that are complaining now about the increased budget and the increased expense of the reserve funding that boards are rightfully doing, I just want to make that clear, that the board is within its rights to do that, to increase these costs for the long-term health, safety, and welfare of the community and its residents. It gives the board some cover looking, just say, look, we don't have a choice, we're just doing this to comply. And that I think is a good thing, and it gives, as an attorney helping our boards out, it gives us something to rely on in the face of membership backlash. Because ultimately what I see then, King gets kicked down the road, no one wants to pay, then we get to the point where it's too deep, we're in too deep, and we have to specially assess a substantial sum, which is also not a good result for those members, and then those same people that told you not to do it the first time complain, and then they don't want to pay that either. So, there's no winning. But on the board, your job, make sure the common areas and elements are well protected, well maintained, and this sort of gives us a a framework, which we're hoping gets smoothed out a little bit for communities. The last thing I want to say is, and there's a couple questions, because the last slide is just a thank you. And this is something now that we've kind of progressed. I have some communities that are now starting to work on some of these SERS items because they know it's either pain now or pain later. The statute is not going away. There may be clarifications. It may reduce the burden a bit, but the statute's not going away. Public policy is too great. Public policy is weighing against us in that regard. So it's not going away. So there's going to be this statute in perpetuity in some various form. The one thing I've seen for the communities that are now what I think is doing the right thing in preparing their membership for what's coming down the pike, there is some clarity that I was going to provide here. A lot of budgets are increasing for a variety of matters. So this kind of applies across the board. Insurance is another one is going up for many communities with pretty substantial increases. There is this kind of misconception that there is a 15% statutory limitation on the max that a board can raise the assessment from year to year. There is a statutory provision that relates to a 15% increase, but what that 15% increase does in the statutes is that if the board goes year over year more than 15%, it gives the owners the right to propose an alternate substitute budget that goes back down below it. It doesn't mean the board did anything wrong. It doesn't mean that at all. It just means that the owners trigger a right to go back to the board and say, we think this budget's too expensive. We want you to rein it in. Here's our proposed budget. The association really only has a limited obligation to notice the meeting at which the members' proposed budget gets produced. And what's interesting about it, though, with respect to all of this, reserves and deferred maintenance are excluded from that 15% calculation. So if you year over year increase, your operating budget really only goes up, 5 to 10%, which is kind of the norm of what I'm seeing at this point for a lot of communities. But the majority of the increase is related to the funding of reserve accounts. That does not trigger that 15% right to challenge the budget. So just keep that in mind, that funding this doesn't just mean, oh, we've gone over our 15%, we can't do it. You may have individual governing document considerations and concerns you've got to look at, maybe with the help of your management company and your attorney. But from a statutory perspective, there isn't just this hard 15% cap. You are entitled to go over it, and it only triggers the right of the owners to challenge it, but it doesn't include reserves or deferred expenses.